May it please the court. I'm Pamela Joe Hatley. I represent Gratz C. Beeler, who is the appellant. He was the plaintiff below. I would like to reserve 4 minutes for rebuttal. We're here on an appeal from a summary judgment. The trial court below granted summary judgment in favor of Pelican Island Property Owners Association, Incorporated. Mr. Beeler contends that the trial court erred because there were genuine issues of material fact in dispute among the parties, and also because the trial court resolved issues of fact in making in granting summary judgment. And also, in the alternative, if this court finds that there are no issues of material fact, then the trial court's decision was wrong on the merits. Mr. Beeler owns his parcel and his home in Pelican Island Development, which is a residential development in Tampa that consists of 3 residential subdivisions. Those subdivisions are evidenced by plats that are recorded in the public records, and their names are Pelican Island Unit 1, Pelican Island Unit 2, and Pelican Island Unit 3. Mr. Beeler's property is in Pelican Island Unit 2. As each of those plats were recorded in the public records, there was also a declaration of covenants that was recorded that ran with those plats. In other words, the declaration of covenants, or the deed restrictions, which I'll use those terms interchangeably, those are covenants running with the land, and they attached to each corresponding plat. The covenants that run with the parcels in Pelican Island Unit 3 do not attach to the parcels in Unit 1, and vice versa. They run only with the parcels that are in the corresponding plats. The original declarations, when they were recorded, did not include a provision for amending the declarations. The Articles of Incorporation for Pelican Island Property Owners Association did have provisions for amending the articles and for amending the bylaws, but not for amending the declarations. The declarations themselves contained provisions for amending the amount of the fee that the owners have to pay to the association each year. Pelican Island Property Owners Association is a homeowners association, as that word is defined in Chapter 720 of the Florida statutes. And it is responsible for operating and serving and enforcing the deed restrictions, or the declarations of covenants, for each of the 3 subdivisions in Pelican Island. In 2013, there were amendments adopted to each of the deed restrictions, each of the declarations of covenants for the 3 subdivisions. Mr. Beeler challenged those amendments below. He challenged them as being contrary to law and unreasonable, and as being vague and ambiguous. He contends that they improperly diluted his vote, or that they altered his vote for the purpose of amending deed restrictions in the future, not for anything else, but just for subsequent deed restriction amendments. Each of the deed restrictions, each of the declarations of covenants for the property owners, or for the plats, the subdivisions, each of them contained an expiration date. That expiration date was actually in paragraph 39 of each of the declarations of covenants, and said that the declarations expired on January 1st, 2010. In 2008, Pelican Island Unit 1 subdivision feared that its declaration was about to be extinguished by operation of the Marketable Record Title Act. Marketable Record Title Act will extinguish declarations that are not repeated in a title transaction for over 30 years, going back to the root of title. So in 2008, because the original declarations were recorded in 1978, the board of directors of Pelican Island Property Owners Associations feared that these were going to be extinguished by Marketable Record Title Act, or MRTA. So the board tried to preserve them. There was a problem with that preservation notice, with that process. It's a statutory process. So in 2008, Unit 1 subdivision went through a revitalization process, and the revitalization process is provided for in Chapter 720, Part 3 of the Florida statutes. It's a very specific process. Only the parcel owners in that particular subdivision could vote on it, and they voted to revitalize their declaration. Subsequently, Pelican Island Subdivision Unit number 2 and 3 also went through that same revitalization process. They had to do it because their deed restrictions were either being extinguished by the Marketable Record Title Act, or they were going to actually expire under their own terms on January 1st, 2010. The point being that the original declarations of covenants are all gone, they're all expired, they're all done away with, and we have revitalized declarations of covenants applicable to each of the subdivisions. Because there was not a provision for amending the declarations of covenants in the original documents, the statutory process for revitalizing declarations of covenants requires that to be added in the revitalization process. So when the declarations for Pelican Island Unit 1, Unit 2, and Unit 3 subdivisions were revitalized, there was a provision added for amending the deed restrictions. That provision provided that the deed restrictions for each of the subdivisions, subsequent amendments could be approved by 2/3 vote of the parcel owners in each subdivision. So parcel owners in Unit 1, 2/3 vote could amend their deed restrictions, the same for Unit 2 and the same for Unit 3. In Mr. Beeler's subdivision, there are 34 parcels. 2/3 of those parcels is 23. So 23 affirmative votes could amend the deed restrictions in Mr. Beeler's subdivision. However, after the adoption of the 2013 amendments, which Mr. Beeler challenged in the process below, that amendment changed the amendment process of the declaration so that it read, amendment of these restrictions shall require the affirmative approval of not less than 2/3 of the 87 parcel owners in the community known as Pelican Island Property Owners Association, Inc. Now, in the first place, that language is nonsensical because Pelican Island Property Owners Association, Inc. is not a community, it's a corporation. But if the intent of it is to require parcel owners in each of the 3 subdivisions to vote on amendments to each other's deed restrictions, which is apparently what the intent is, then the effect is unreasonable. In the case Nell versus Lock Haven, the Court of Appeal held that declarations of covenants are enforceable by remote grantees in title. So a grantor, a person who owns a swath of land, can subdivide that land and can record declaration of covenants that runs with the land, and subsequent grantees in title then would be subject to those restrictions. So the reason they're continue to be enforceable by remote grantees in title is because it's recorded in the public records, it becomes a covenant running with the land, and people who subsequently buy are aware of it and know of it, and they buy that contract basically as a pertinent to their title. In that case also, the court said that subsequent amendments to that declaration have to be reasonable. And so that's the test, a test of reasonableness. So in the instant case, we have 3 subdivisions with covenants that run with the land of each subdivision, people who buy knowing, and remote grantees in title in each subdivision, knowing that they are subject to these specific restrictions that apply to their subdivision and not the others. They have some control over those restrictions, those covenants. But when this amendment happened, was adopted, then we have other people who are in control. Now Mr. Beeler is no longer one of 34 parcel owners in Pelican Island Unit 2 who can control his deed restrictions, subsequent amendments to them. Now he is one of 87 of the entire development, of all the members of the association, one of 87. And in fact, it no longer takes 24 affirmative votes in Pelican Island Unit 2 to amend their deed restriction. It takes only 5 if all the others, all the owners in Pelican Island Unit 1 and the owners in Pelican Island Unit 3 voted to amend Unit 2 deed restrictions. Only 5 people in Unit 2 could affirmatively vote, and they would be amended, even though the other 29 in Pelican Island Unit 2 voted against it. So,
or conversely, the members of that unit might perceive the need to amend the restrictions and vote unanimously to do it, 34. And members of the other subdivisions might not have cared at all and didn't bother to vote. And that vote would fail, would it not?
Absolutely, because as it stands with 87, it requires 2/3 would be 58 votes. If it didn't get 58 votes, it wouldn't pass, even though the unit owner or the parcel owners in that subdivision wished it to be passed.
Unanimously. And theoretically, then there would be no votes because no one else bothered to vote, and it couldn't be done.
Right. So this is the reason Mr. Beeler asserts that the 2013 amendments were not reasonable. In the trial court's summary judgment, the court also erred in resolving certain issues of fact. For example, in the summary judgment order, the court made no finding that there were no issues of fact in dispute outstanding. The court did make certain findings. For one thing, the court held that the Property Owners Association consistently voted on the basis of one vote per 87 members, including on votes to amend its deed restrictions until the 2008 amendment to deed restriction for Pelican Island Unit Number 1. This was a fact that was in dispute, and it goes to the allegation by the Property Owners Association that in 2008, Mr. Beeler, who was on the board at that time, and Mr. Mangan, who was also a plaintiff below and was on the board at that time, the Property Owners Association alleges that those two essentially hatched up this plan to add an amendment provision to the declaration. And that isn't true, as explained in the briefs, and I explained this morning. The amendment provision had to be added because of the statutory process for revitalizing deed restrictions required that provision to be added if there wasn't one in the original documents. Also, the court's finding that the association has always voted on a membership-wide basis to amend deed restrictions is simply not true, because when the deed restrictions for Unit 1 were expiring or were set to be extinguished by the Marketable Record Title Act, only Unit Number 1 parcel owners voted to revitalize that document. And when the parcel owners in Subdivision 2 and 3 were up for revitalizing their documents, only those parcel owners in those subdivisions voted. And that's the statutory process requires that. Only the affected parcel owners can vote to revitalize their deed restrictions. So that finding by the court was in dispute, and the court made a resolution of that dispute, a factual finding. The court also found that The plaintiffs claim that the voting interests were materially or adversely altered in violation of Florida Statute 72306, Parent 1, Parent C, are defeated because that statutory provision also says, unless otherwise provided in the governing documents, and that suggests that the original governing documents did have that provision, and of course that was disputed in the case below. So that was also a finding of fact that was disputed. And finally, there was further findings by the court that the 2013 deed restriction is not vague or ambiguous. The court doesn't explain how it should be understood or how it should be interpreted, or it doesn't explain the language, why the language refers to 87 parcel owners in the community known as Pelican Island Property Owners Association, Inc., how one could make sense of that, but that was a disputed issue in the case below as well.
Ms. Hatley, you're coming down to your 4 minutes. So
okay.
Proceed as you wish.
Finally, if this court finds that there were no issues of fact in dispute, Mr. Beeler contends that the decision should be reversed and summary judgment should be granted in his favor because the 2013 amendments were contrary to the law and did dilute his vote and did have that effect and therefore were not reasonable. Thank you.
Thank you.
Good morning, Your Honors. Daniel Sachs on behalf of Pelican Island Property Owners Association, along with my daughter, Rachel Sadi Sachs. She's a pre-law student at UCF. Oh, cool. She's provided some assistance to me on this brief, and she's here today to join me in representing our client. Despite the voluminous record in this case and significant filings by both sides, there's essentially one issue here, and that is whether a March 29, 2013 deed restriction amendment, quote, materially and adversely altered, close quote, appellant's voting rights in violation of Florida Statute 72306(1)(c). This is how the case was presented in appellant's August 5, 2013, 11-page, 84-paragraph, one-count complaint, which sought declaratory and injunctive relief based upon that argument. Now, on this appeal, appellant argues, notwithstanding his contrary argument below on summary judgment, that there are in fact fact issues that require a trial. And the claim is essentially predicated on three arguments. The first is claimed ambiguities in governing documents in the declarations of covenants in the three Pelican Island units generated different interpretations by Pelican Island and the appellant, which interpretations were improperly resolved by the trial court against Mr. Beeler. Secondly, that these differing interpretations between Pelican Island and Mr. Beeler concerning these ambiguities were improperly resolved against Mr. Beeler. And third, that these claimed ambiguities and contradictions raise fact issues that should have precluded summary judgment. And these general arguments are supplemented and expanded upon in the reply brief, which argues that there are material fact issues relating to amendments of deed restrictions in these three units, and that the original deed restrictions did not have amendment provisions, which was the reason for the 2008 amendment. You heard more of that here today. The 72306 argument is, I think, easily dealt with. That argument is that voting rights were materially and adversely altered by the 2013 Pelican Island Deed Restriction Amendment. That argument completely ignores the first part of that sentence, which provides, quote, unless otherwise provided in the governing documents as originally recorded or permitted by this chapter or Chapter 617. It is simply not disputed that the originally recorded Pelican Island governing documents, specifically Article of Incorporation 4.1 and Bylaw Article 3, unequivocally provide that Pelican Island voting is done on the basis of one vote for each of 87 members. All voting is done that way, including voting on deed restriction amendments. And these governing document provisions have never been changed. They were in place when appellant bought his home.
Did the Articles of Incorporation say that voting on deed restrictions is done by all 87 unit owners?
They did not specifically call out deed restrictions, Your Honor. They didn't specifically call out particular pieces of the governing documents any more than Florida statute identifies particular.
I mean, as I understand opposing counsel's argument, she's saying there's a difference between voting on corporate issues related to the governance of the corporation and the bylaws and things like that, and issues relating to the covenants running with the land, which are, separate issue.
Well, first of all, the statute that they're suing under makes no such distinction. It's a homeowner statute. It's making an argument that the voting given under 720, Chapter 720, cannot be modified. That's the statute that they chose to sue under. Secondly, the governing documents makes no such distinction. And thirdly, the manner in which the votes were taken over the years up through 2008 were all done, including voting on deed restrictions, by the manner in which they were laid out in the governing documents. And we've laid out specific instances in the record, time after time. And
well, it sort of assumes what you have to prove if you say it was done in accordance with what was said in the governing documents when you're referring to the Articles of Incorporation and the bylaws.
Well, what I'm saying, Your Honor, is that the bylaws, the governing documents, can only be read to mean all voting, because they don't say it any other way. And the clearest evidence of that fact is to look at the history of how voting was done at Pelican Island, and you will see that it was done on that basis. It was only changed in 2008 when Mr. Beeler and Mr. Mangan, who were on the board at that time, decided that and persuaded a majority of the Pelican Island Association that it should be done differently, and that an Article 41 had to be added, and it was added. And I think it's also significant that there's no dispute here about the manner in which these amendments were done. And all that happened in 2013 was exactly what happened in 2008, done in the same way. And the association members, all 87, decided that they didn't want to have the amendment as it was done on Article 41 in 2008. They changed it back to the way it had been historically done. And it's also interesting that when this amendment was done in 2008, it was done based upon 87 votes. They did the same exact procedure set out in the governing documents. They sent out ballots, they sent out notices to all 87 members in the association to come to a vote at an annual meeting. They came to the vote, and all 87 members voted on Article 41. All that's happened in 2013 is the exact process with a different result. The result being a return to the way voting was done historically and is set out in the governing documents, which again, and I think this is important, were never changed. The point of, at least in our view, the Florida statute 720-306 voting rights provision is to ensure that the association cannot change a member's voting rights to their detriment after the fact, unless everyone agrees. That, to us, is what the statute is there for. But the statute very clearly makes an exception if the complaint of voting provision was in place in the original filed documents. Then you're on notice when you bought in. And that is exactly what happened here. All that Pelican Island did in the 2013 amendment was to modify deed restriction voting back to what it was prior to the 2008 amendment. Everything else in this case, to be honest, the 3-unit argument, the subdivision argument, Mr. Beeler's opinion, all of this is, as Faulkner said, sound and fury signifying nothing. There is one issue that was brought to this court and brought to the trial court, and that is were Mr. Beeler's voting rights materially altered. The answer is no, because of the first part of that very same sentence. The trial judge got it right, and he should be affirmed. As to the issue of ambiguities in the governing documents, appellant recognized there were no such ambiguities when he filed his own motion for summary judgment. He only changed his mind when he lost to the association's summary judgment. There is no dispute here, for example, concerning the word subdivision, and you heard it mentioned in counsel's argument earlier this morning. All you need to do is read Article 3 of the Pelican Island bylaws. That's Volume 3, page 552 of the record, which describes Pelican Island as a subdivision. of units 1, 2, and 3. Subdivision in the context of Pelican Island means the association, not subdivision 1, subdivision 2, subdivision 3. That's in the governing documents. That's what was there when Mr. Beeler came to Pelican.
Are there separate plats for each subdivision, or each unit, I mean?
Each unit is platted.
Separately?
That's the way the development was done, separately. But again, we're talking about voting rights, and we're talking about control of the association of which the units are a part. We're not talking about covenants running with the land or that sort of thing. We're talking specifically about voting rights of Pelican Island members, which are very clearly set forth in the governing documents. There is no evidence that the units are separate associations or have separate voting rights, and that is simply not a disputed fact. There's no ambiguity, for example, concerning the 2013 Pelican Island Amendment. The amendment is clear. I would submit to you that the appellant just doesn't like the result. Again, the same process was used as was used in the 2008 amendment. 87 members voted in 2008. 87 members voted in 2013. How can the appellant complain about the identical process that was used to create Article 41 in the first place? How can he complain that his association members, all 87, decided to take it back to what it was when the governing documents were originally filed? I want to address briefly, the council mentioned some case law, and what's interesting here is that there's not a lot of case law out there on this specific issue. And I would submit to you the reason for that is that the statute is rather clear, and it's plain on its face. And again, the point of it is to protect voting rights and voting interests from material alteration or dilution, but not where the complaint of action was provided in the original recorded documents as we have here. The governing documents are clear, and Florida law is clear. And the cases make that point quite well. The case originally cited by the appellant, the Holiday Pines Property Owners Association case versus Wetherington, it's at 596 South 2nd 84. It's cited at length by the appellant, but I think the appellant misses the point that the facts were substantially different in that case. In that case, the association was developed from 1978 through 1987 as 4 separate entities with correspondingly separate deeds and restrictions applicable to each. In 1983, the members wrote an amended set of covenants applicable to all the plats, which, among other things, provided for formation of a homeowners association with recorded bylaws, including the right to make and amend regulations governing the use of property in that subdivision. Under the 83 amendments, membership in the homeowners association was entirely voluntary. The deed restrictions were amended again in 87, most significantly to provide, and now for the first time, that mandatory membership in the homeowners association. This, the appellate court found, was a fundamental change in the scheme of development, rendering the 87 amendments unenforceable. And those are not the facts in this case. While Pelican Island is comprised of 3 units, the originally filed governing documents reflect the unitary nature of the association, including, most importantly, voting based upon 1 vote for each of the entire Pelican Island members. And cases following Holiday Pines make that point. There's a case, Zerquera versus Centennial Homeowners Association, Inc., which is at 721 South 2nd, 751. The homeowner sought review from an adverse judgment, denying him relief from certain fines levied against him for violations of amended declaration provisions. The court denied plaintiff Zerquera's argument that amended covenants were not enforceable because he purchased property prior to the amendment. The court affirmed the trial court's ruling as to Zerquera, and it describes him as a disgruntled homeowner who does not wish to abide by association rules. That, at the heart of it, is the problem we have in this case. We have a disgruntled homeowner who doesn't like to abide by rules which he clearly understands. He clearly understood when he came. He's now changed his mind. And there's a case, Kleinow versus Island Court at Boca West Property Owners Association, which is at 64 South 3rd, 177. The court there affirmed the trial court's judgment against the homeowner's argument that their substantive and procedural due process rights were violated by annual meeting voting approving certain beautification projects. In citing Holiday Pines, the court described the test for enforceability of an amendment for restrictive covenants as reasonableness, and I do agree with counsel, it has to be reasonable, which was defined as not arbitrary, capricious, or in bad faith. Or in other words, you cannot destroy the general plan of development or be a radical change of plan from what was originally contemplated and conceived for that property. The Kleinau court described radical change as a change which would create an inconsistent scheme or a deviation in benefit from that of the grantee to the grantor. In our case, there was no change at all, much less a radical change. Appellants complained of voting rights are the same as those conveyed to him in the originally filed governing documents, one vote out of 87 association members. And lastly, the case Luani Plaza Inc. versus Burton. It's a recent case from the 3rd DCA. I don't have a legal, it is 149 South 3rd, 712. I just found a legal site yesterday. The issue before the court required interpretation of declaration of covenants, conditions, and restrictions. This was a commercial plaza, not a residential one. The court rejected plaintiff's argument that a declaration unreasonably and arbitrarily denied him the use of his own private property and that the amendment was being impermissibly applied against him retroactively. The court affirmed the trial court in all respects and found that the complained of amendment was reasonable and not exercised in a manner so as to destroy the general plan of development. Again, the same result should obtain in the instant case. The general plan of development was 3 units governed by an association, voting rights, 87 members, and that's how it was consistently done. Nothing has changed with the 2013 amendment. It just went back to what it was when this association was founded back in 1978. There are neither ambiguities nor material facts in dispute, and I believe respectfully that the trial judge was correct in finding summary judgment for our client, that the declaratory judgment complaint to that appellant's voting interests were materially adversely altered by this 2013 deed restriction were rejected. The 723-061C claim is defeated by virtue of clear and undisputed voting provisions in the originally filed Pelican Island documents and the further fact that the 2013 amendment was not vague or ambiguous. The appellant just doesn't like the result. He is, in our view, a disgruntled homeowner. He knows what the rules are. The rules have not changed. The point of this statute is you cannot bait and switch. You cannot bring a member to an association with a certain set of rules on voting and then change those rules when he's been there for a few years. That is precisely what did not happen here, and the trial judge should be affirmed. Thank you.
Thank you, Mr. Sachs.
May it please the court. I have to address the issue that was raised repeatedly that in 2008 it was asserted that the vote to revitalize the Pelican Island Unit 1 declaration was made on a membership-wide vote. That is not true. That is not the case. In the revitalization process where paragraph 41 was added, that amendment provision was added, that was done only on a vote of Pelican Island property owners in Unit 1. And in fact, the Property Owners Association in its 4th affirmative defense admitted that. It said that the deed restriction, Article 41, was added to Unit 1 deed restrictions in 2008 and to Units 2 and 3 deed restrictions in 2011 as part of a revitalization process. The amendments were done by majority vote in each respective unit. That's true. That's how they were done. Mr. Fabriga, who is the president of the Property Owners Association at the time, also agreed with that in his deposition. In his deposition on page 80, he was being asked about his affidavit, which was contrary to the affirmative defense that was raised. And he was asked, so is that correct at this meeting, that is the 2008 annual meeting of all the membership, was that where Article 41 was approved for Unit 1? And he answered no. He said, no, Article 41, you have to go through a revitalization process, and when you go through that process, you need to get the votes of 51% of the residents of Unit 1. He agreed with that. So I'm not sure where that confusion came in, but clearly the statutory process in Section 7, Chapter 720, Part 3 for homeowner association declarations requires just the affected parcel owners to approve that revitalized declaration, not in this case the association-wide vote. That did not happen. Mr. Beeler argued in the case below that on his summary judgment that there were no facts in dispute because his case is based on the instruments of record. All the facts are in the instruments. And so based on the instruments of record, which can't really be argued with, he argued there were no facts in dispute because those instruments were essentially admitted by the Property Owners Association. But the association raised issues, and they did raise what are ambiguities in those documents. For example, the bylaws. From 1978 until 2011, the bylaws did not define subdivision as being Pelican Island Unit 1 and Unit 2 and Unit 3 and a recitation to the recorded plats. It simply said, the bylaws simply referred to the Pelican Island subdivision. And so referring to the Pelican Island subdivision apparently, it creates an ambiguity with the fact that there are actually 3 recorded plats, 3 subdivisions. In 2011, the bylaws were amended, and now they actually refer to those 3 separate plats. There has been throughout this case a criticism of Mr. Beeler as calling names and demonizing him. In fact, he is not a disgruntled homeowner. He has been in this community for many years. His deed is in the record. It shows you how long he's been there. He has served on the board. His signature is on some of the recorded instruments. He is not disgruntled. That is not his purpose in bringing this case. And so to that extent, I just had to address that. We, in conclusion, respectfully ask that the court reverse the trial judge summary judgment and either remand it for trial on the merits because there were issues of fact in dispute, or grant summary judgment in favor of Mr. Beeler because the amendments were contrary to the law and unreasonable. Thank you.